Thank you very much. Everybody remembers where they were at that time. Yesterday, I thanked some of our staff, and there's a couple more I want to thank also. Anna Moak is over here. She helped do a lot of the work on putting this event together. And then I also want to thank our council, Jeff Roseman, who's a great, I'm blessed to have our committee is blessed to have wonderful council helping us with all these issues. And yesterday, we dealt with issues on surplus lines in the wind pool, and another subject that the Lieutenant Governor wanted us to study further because of bills we had last session and anticipated additional bills that we might have the next 3 years, are issues that deal with workers' compensation laws in Mississippi. And so the first person I'd like to introduce is going to give us an overall study, for lack of a better term, of how our workers' comp laws were originated and how they operate. And we're blessed to have 3 speakers. Going to ask that you keep your comments to about 15 to 20 minutes. When you get about 2 minutes away, I'll give you the 2-minute warning, and then that will allow us all to have plenty of time for questions as well. So Chairman of the Workers' Compensation Commissioner and former representative and former Chairman of the Insurance Committee in the House, Mark Formby, we appreciate your being here this morning, and we'd like you to kick it off for us, please.
Thank you, Mr. Chairman, and it's good to be back in the building. It's good to see friends. It's really good to see a lot of workers' comp community because we see each other a lot prior to COVID, and we haven't seen each other all summer. So it's good to see everybody, the practitioners of the industry as well. As you stated, Mr. Chairman, you kind of asked me to give a primer, and in 15 minutes, obviously, we can't go through the code or the act. But I'm going to give a fairly shallow primer of what it is we do. For some of you, this will be old hat, and hopefully it'll enlighten others. I do want to recognize this morning, I have with me the other 2 commissioners. I have Commissioner Beth Harkins Aldridge, and Commissioner Mark Henry, and they are seated back behind me. And I'm going to let them handle the answer part to the question part. So I'm going to give my primer, and then if there are questions, we'll let them answer the questions. I also have our senior counsel, two staff attorneys that are here this morning. We have Megan Garrett and Jeff Skelton, and they're back here also. So I don't think that Ray Miner came, but a lot of y'all in the room are familiar with the executive director over there. He's been there for a long, long time. So first of all, just an overview of workers' comp itself. Workers' comp is an insurance program. It's a no-fault insurance program. It's mandated by law for all employers that have over 5 employees. There are, like everything, there are some exceptions, but generally speaking, if you have 5 employees, you are subject to the workers' comp laws, and you have to go out and purchase workers' comp insurance. Workers' comp is paid for by the employers, and it generally covers any injury on the job. That includes, to some degree, if you're messing around. I mean, if you're on the job, or if you have a prior injury that you re-injure on the job, you're pretty much covered under the workers' comp insurance plan. There are not a lot of questions asked. By design, it was created that way. Mississippi was the last state in America, I believe, to pass the workers' comp national language. We passed it in 1948. And I think that's when Senator Kirby had probably just gotten here around that time, but and Senator Horn maybe. But Mississippi passed it in 1948, and it has been ongoing, and it has been massaged over the years, and there have been obvious changes. But the general roots of the Workers' Comp Act says that if you get hurt, we take care of you. There's no deductible. There's shouldn't be a lot of discussion. You're injured, you're on the job, and we're going to take care of you. Obviously, there are times, and we'll get into that in a moment, where that isn't the case. When you are hurt, workers' comp covers just almost everything from your initial x-rays, stitches, and visits to surgeries and knee replacements and prosthetics. Workers' comp has retrofitted a house. If you hurt severely enough that you needed to have your home retrofitted, or a special vehicle, workers' comp has paid for that. So it's just about anything that it takes to resolve your injury from a medical standpoint. In addition to that, there are benefits for compensation, both for your salary replacement and even for death benefits. Salary replacement is not a true replacement of your salary. It's 2/3 of your average weekly wage for a period of time, and that's determined, based on the injury. But it's 2/3 of your average weekly wage, and it caps out. So if your average weekly wage is $1,000, 2/3 of that, would be $7-something, and then you would actually get about 498, I think is where we are now. But it caps out, and it's 2/3 up to that cap. There are some death benefits also. There's some funeral benefits and some survivor benefits. It's not life insurance. It's not huge, but it's an additional something to help a family through a tough time, and again, provided through the workers' comp process. That's a general overview of the actual act, and in order to, I'm going to skip a little forward to keep us within our time frame. So the act is on the books. That's something y'all do. Whatever changes are made, you handle that. We get lots of ideas and complaints. People call us with suggestions. When I first got over there, I put out just to all the practitioners and all the staff, I think like any new person would do, I started asking questions. So we got lots of input from the community, and we implemented some changes from that input. The commission itself, the 3 commissioners that are here, myself and the 2 others, our job, we are governor appointees, direct appointees. Governor appoints us, and then y'all confirm us. The overall job that we have is threefold. We are regulators. We regulate all the industry. Private companies, obviously, with the Department of Insurance, but we pretty much have total oversight over self-insureds. They come in 2 varieties. They come as just a business that qualifies to self-insure, and then there are some groups, all told over 100. And so we have direct regulation over them, over their books and their surpluses, and if they get to a point where they need to be dissolved, we do that. We are also adjudicators. We have 8 staff attorneys, and so of the cases that we have 13,000 cases a year, plus or minus, some 10.5 to 13.5, and of those, some 2,500, again, more or less, will be controverted or contested, and then those fall into that process. Some people some injured workers will hire attorneys, and should in many cases. Some will fight their case themselves, but ultimately, once that case has been contested, once there's an issue with it, then ultimately the 2 of the 3 of us have to sign off on that case. Now, as they go through the process, if they want to bring it to workers' comp court, we have 8 judges. The 8 judges divide the state into 4 quadrants, and there are 2 that serve each quadrant. Those rotate, so you don't get the same judges there in perpetuity. So those judges rotate around the state, and they hear cases. They ultimately decide those cases, and that is the end of it, unless there is an appeal. If they appeal either side, then it comes before the full commission. We hear those cases 2 ways and then decide those cases. We either hear them in oral arguments where we have open court, or we hear them on the record where the 3 of us will go in and review all the information that has been presented to us and ultimately make a decision. And it can be a 2-3 decision, so as long as 2 agree. The third thing, and then if it's appealed further, then it would go to the Supreme Court. So you have the 8 judges, and then the commission, and then the Supreme Court ultimately gets the case. They can hear it, they can hand it down to the Court of Appeals, but that's where the buck stops. And then finally, we just administer the agency. The 3 of us work hand in glove daily. The executive director has a lot of day-to-day responsibilities. As chairman, I kind of hold the gavel over the meetings, and then I have some additional authority from an administrative standpoint, but we function as a body. The commission meets and we make decisions, as a body, and that's a great way to do it because we have 3 different personalities, 3 different backgrounds. We all bring something different to the table, and I think that it has created a very smooth operation over there. There are obviously, concerns that we'd still like to address. The chairman also asked that I address a few of the major issues. These are not necessarily issues that the commission brought forward or anything. That's just the bills that you asked me to talk about. I'm going to walk through the components of those. Some we did ask for. Some came from our staff that they thought would help provide cleanup language to the act. So the big issues come from House Bill 461, and I believe it was Senate Bill 2798. That's close, but those were the 2 big bills that came forward. The issues in those were mirror bills. We passed in 2012 some workers' comp reform. One of the things that we said then, and it's in our rule now, it's in Rule 2.5 now, is that you're required to provide medical documentation of your injury, which obviously should make sense to anyone. And then it says that you have 30 days to do that, and that's the way the law was written. What we have found is that if people don't provide medical documentation, we have no hammer. We have no way to encourage them to do that. And ultimately, if they didn't and had no benefits, then the statute of limitations could get them. So especially if you have an unrepresented claimant, if they have an attorney, then generally the attorney who does this for a living is going to stay on top of it. But in a situation where they don't, obviously it would apply to both, but in a situation where they don't, they actually could end up hitting the statute of limitations and they lose all benefits. That's a hard line, and they lose all benefits because they weren't notified. So that bill did come from us, and it asked that we put the rule that we have into law, and it would just say that we get to notify them and inform them of what the law says, that if you don't provide this, or what the rule says, if you don't provide medical information, then we may dismiss your claim. We're not trying to dismiss anybody's claim. We're actually trying to encourage them to get it in because ultimately it's dismissed. Ultimately, if we don't do something, they hit a hard deadline. The other thing in that bill, the other component of that bill is that we do have a number, it's a smaller number, but we have a number of injured workers, claimants that represent themselves through the process. And again, because of hard statute deadlines, I have asked that we require employers and carriers to notify a claimant, I can't remember if it's 30 days or 60 days, but some period of time before that statute runs. So if you have a claimant that's out there, they haven't done anything, they did file the injury and it's an accepted injury, but it's been quiet. Again, if they have an attorney, that attorney's going to keep them on track. If they don't, I just think it's fair to let an unrepresented claimant know, just be notified that if you don't do something in the next, and again, I can't remember if it's 30 or 60 in the bill, but if you don't do something fairly immediately, you're going to hit a hard statute, and once the statute of limitations comes, then your claim is dead. I think that's fair, and I certainly endorse that. By the way, as I go through these, I'm going to state a position. Most of these are mine. That's what you've asked me to do. The commission is a body. The commission itself may or may not agree on all of these, but I'm trying to give you both sides. So the last thing that we've asked for, and we did ask for this as a group, was to be able to allow electronic filing in a myriad of situations. I mean, most other agencies have, and so we just like to be able to go through and accept notification for renewals and non-renewals and cancellation by electronic means with a receipt, obviously, which is just pretty commonly done. The other big component in the bill, and y'all did not see this bill, I don't think the committee ever considered this bill. The House version came over, but the other big component in this bill, is going to be addressed, Seth Thompson's going to address this specifically, but the issue is the Freedom of Information or Public Records Act and our list of injured workers. So I'm going to sort of close out and discuss that, because I'll tell you the way it came on my radar screen. Obviously, when I got over there, this was not something I was aware of. I had a pro se claimant, and I said this in front of the committee before, so it's not anything that I had an injured worker, and we were settling the case. It was done. He was agreeing. We were fixing to finish. And as part of my speech, I always say to a pro se claimant who is representing himself, I remind them, first of all, that they're not unrepresented. They've chosen to represent themselves. And I also remind them that if they thought they needed an attorney, they could hire an attorney. And right down to the wire, I think all three of us do that. In pro se cases, especially if it appears they're having issues, sometimes we will just tell them, you need to go hire a lawyer. Well, I made the comment, and this pro se claimant said, well, I didn't hire one, but it wasn't for lack of them trying, or something to that effect. It just kind of went over my head, but after he left, I asked somebody what they meant, or he said he got some mailings, and I just, you know, out of my own ignorance at the time, I just asked how they got the names, and I was informed that the way the attorneys get the names of our injured workers is that we mail them to them. At the end of every month, we send out a list of those who request it. And apparently that's what the law says, and that's what we're going to continue to do. From my personal viewpoint, it seemed odd to me that a state agency was doing that, you know, notifying somebody that somebody was injured. But then, over the course of time, I began to hear from lots of people. And while there are certainly claimants' attorneys on both sides of this issue, and I get that also for obvious reasons, and they will explain that, the bill that y'all actually saw this year, Mr. Chairman, that came to you, that was not in 417 or 20, the standalone bill, that was basically filed by a group of claimants' attorneys. So within their own part of the bar, they're arguing over that. Again, that's the issue, whether we send it out or whether we don't. Like everything else in the workers' comp arena, we're going to enforce the law. We all have our opinions. That's even true with personal ideology. You know, we're across the board on the way we think many times over the course of the years in turnover in the agency, but we are sworn to uphold the law that y'all provide. So whatever you tell us to do, that's what we will do, but those are the issues at hand. The last thing that I will say, and then I'll sit down or take questions at the proper time. Somebody asked me when we walked in about COVID cases. We've had a few over almost 800. We've had almost 800 COVID cases filed. 5 of those, I believe, to date are on the docket to be heard by an attorney. I'm not going to elaborate where we're going with that because I don't really know where we're going with that, but certainly those cases are hitting us, and there are certainly people out there who are claiming that their COVID case was something that they call at work. So we will see where that goes. Mr. Chairman, would you like me to sit and let everybody speak and then take questions, or would you like me to take questions?
Take questions now, please.
Okay, well, I'd sure be glad to answer any questions that we have. Certainly, you know, because there are lots of other issues, as y'all know, and having chaired the House committee, there will be 30 or 40 bills every year filed dealing with workers' comp. We generally will consider one or two of those about once a decade is the way it works. Let me say this, because it was on here. Okay, have I got just one more second? Yes, sir. One of the things that we have asked for is our special fund status back. As you know, we swept them all, and then we have fed them back. There have been some that got back. This year is a good example of a year where there were across-the-board budget cuts, ours included, a true budget cut, a true cut from last year. Sometimes it's not the old we got cut a percentage of the increase we asked for. It is a true cut. And so when that happens to us, you know, we've gone from 74 employees down to about 58. We are running lean and mean, and our budget's very close, and we've done that on purpose because that's what you would want us to do. But then when we get in this situation, it really is tight. And the frustrating thing from my point of view as a administrator, taxpayer, former legislator, is that whether we get more money or whether we get less money does not affect the taxpayers of the state. Our money does not come from the general fund, not a dime. If you cut us $50,000, you don't save $50,000 because the way we get our funding is that we then go out to those people that we regulate, like the Banking Commission, which is still special fund. We go out to those industries that we regulate, and whatever you approve, we divide that amongst them by their percentage of the market, and then that's how much we get. So if we get cut 100,000 or 50,000 or a dollar, nobody benefits from that. We lose it, but the beneficiaries are the companies that we regulate. 85% of those companies are out of state. We have one domestic company here, AmFed, and then our self-insureds, and who, by the way, supported us on this. So they know that we've worked very hard to run a conservative, fiscally conservative agency. So I would obviously like to keep that alive and implore you that it's the right thing to do, I think, and certainly there's no benefit financially to the legislature or the taxpayers or the budget by not doing it. I mean, we literally, the money comes from somewhere else. What happened this time, we got cut $200-something thousand, so we basically just had to lower the rate, send the bills. They're going to send us $200,000 less. Y'all don't get it, we don't get it, and no one company even enjoys a big cut because there are enough of them that it's several $1,000s a piece to them. So anyway, that's my land yap. I'll be glad to take questions.
I'll ask you a question about the employer exemption in Mississippi, 5 or less. How does that compare to southeastern states?
It's varied, even among southeastern state, and it ranges from 0 to 5. I've reviewed this many times, and I'm not sure exactly which states do. I have counsel here that might answer it more specifically, but the answer is that it varies. 5, I think 5 is the most nationwide now, but there are certainly states that have 0 if you have an employee. Now, they still maintain the exemptions for ag workers and certain other domestic help. There are certain issues, certain job descriptions that are still excluded, but generally it's 5. To get down into the weeds, if you're the owner of the company and the manager and you work hands-on, you may or may not have to count in the 5. But 5 is the number. I know that there are bills filed every year to change that. That would be, I think, something that would be worthy of a separate and in-depth discussion at some point, because obviously if you have 0, your first employee you had by workers' comp, that sounds wonderful to some degree because it take out a whole lot of our, threshold adjudication, was it or was it not? But that also means then that if you are a sole practitioner in insurance or real estate or some other business, and you had one staff member, that would, this body would have to decide, do you want to force all those people to file workers' comp for a person that sits at a desk and does their reception work all day, for instance. So, it'd be, it's like everything else. When I got over there, the first thing I asked everybody, judges included, to do was to pour through the act, and if you have a personal opinion, let me know what it is. I wanted a personal opinion because these are the people, the practitioners. There are practitioners in this room that will know more about this than I will ever know. That's what they do for a living. They did it for a living before I got here. They will do it for a living after I'm gone. So cumulatively, there is a lot of knowledge. I have an advisory committee that's statutory that y'all provided for me, and that advisory committee is made up of pieces of the workers' comp community, doctors, lawyers, and others. And so, anything that you ask the advisory committee to research, I'm sure that they would do that also and make recommendations. And that's their field. And you've got good representation, I think, quality representation from all parts of the workers' comp industry on that advisory committee. So that'd be a tool for you, Mr. Chairman, if you decided to use it.
Senator Blackman has a question.
Thank you, Mr. Chairman. Following up with what the chairman said, what are do we know where we stand in our surrounding states with our statutory limits?
Again, it's mixed. We're right where we are right now is we're based on average weekly wage. That in and of itself is defining, because when you have a state that has, a higher number of low wages and you average all the wages out, then it's going to be lower. If we by hook or crook brought in 15 new manufacturing facilities and bumped up a whole lot of the lower end, then that average weekly wage would move up. But ours, both by percentage and by actual amount, is probably, I haven't researched these states, but I'm going to guess that we would be similar to Arkansas, West Virginia, the states that we tend to be economically aligned with. But statutorily, for instance, Louisiana, and I've got counsel that might answer, but even if they are the exact same, if their average weekly wage, the number itself is higher, then the benefits will be better because it's based on that.
Is it possible for your staff to provide me with that information?
Absolutely, absolutely. I think it's on our website actually, but we will we'll provide it back to the chairman, and we will break it down. We sure will.
For the surrounding states?
Surrounding states. We'll get that. Senator, I've got it. I know I've got it laying on my desk somewhere because I have looked at it many times, and we'll be glad to provide that.
Thank you.
Else? Senator Horn?
Thank you, Mr. Chairman. Commissioner, could you tell me what the average death benefit is?
Yes, sir. Well, I'm not sure about the average. The statutory death benefit, again, is a benefit that is provided through workers' comp, but it is, again, I was part of the change. We raised it to $5,000 for funeral benefits in 2012. Prior to that, it had been $1,000. And of course, for a family, $5,000 is still about probably half of what it would cost for a real funeral. But that benefit is there for funeral benefits, again, through workers' comp. It's not a life insurance or a burial policy. The benefits to the family, you have a widow's benefit, and then you have a benefit that involves other dependents that are proven dependents, and that is based, again, as I mentioned to Senator Blackman, that that's based on weeks of service, up to 450 weeks based on their average weekly wage. And then is the 1,000? And if you have more benefits, then it does still cap out. So I mean, if you had 10 kids versus 5 kids, the benefit is not still, it still caps out. So it's still spread by a cap to those children.
So no benefit extends beyond 450 weeks?
That's correct.
That's
450
across
weeks,
the board.
that's the max for, also for total limb loss. 100% loss, whether it's death or for a loss of a limb, the max in Mississippi by the legislature's order is 450 weeks.
Okay, so if I'm a 25-year-old worker and I lost a leg as a result of an accident on the job, I get workers' comp. The most that workers' comp will cover me is 450 weeks at 2/3 of my weekly salary.
The most that it would cover, 100% loss of a limb would be 175 times 2/3 up to the cap of your average weekly wage for 450 weeks. So if it caps, it would actually be less than your
So
average weekly wage.
what's the cap? And how is it determined?
The cap is set by the total number of claims, I believe. It bumps, it moves with the market, so.
The average weekly wage each year is determined by the state average weekly wage. And so the compensation rate, the state average weekly wage is added up, and then the comp rate is 2/3 of that. So if the state average weekly wage is $1,000, the max would be $667 per week. There's two types of injuries. So for example, below it, that's a scheduled member. So there's scheduled member injuries that's in 71.3 or 71.317, and it gives us a list of skills that your mostly your extremities, your arms, your fingers, your legs, and then from that you also have body as a whole, which are backs, necks, all of that. And body as a whole injury is the whole time, 450 weeks. But then the amount that you're paid is adjusted based on your loss of wage earning capacity. Then with your scheduled member, you get your full compensation rate, but for a limited period of time. And the burden is a little bit less to the scheduled member based on loss of wage earning capacity.
And as we calculate, as the commissioners calculate, we get that schedule, and so then we just base, we base our approval of the claims on that schedule.
Okay, and on the point about the request for exclusion from the Public Records Act, is anybody else collecting this data from you all, aside from attorneys?
We report broad data to, I think NCCI and I think maybe even others. We report broad data and collect broad data. We even have, if you go through and look at our website, it will tell you how many cases we had last year and that sort of thing. As far as I know, of course, I guess anybody else could, but as far as I know, no one else is requesting the actual list of injured worker per month by name and address, as far as I know.
So lawyers are the only group that's making those requests.
I might answer that better on my staff. I think there are like 12 firms that do that. Of those 12, 4 of them are telling me that they are opposed to it, have contacted me personally, but they're doing it because they feel like they have to do it to compete. Now, again, I'm not even sure that we agree as individual commissioners. I'm just trying to answer your question.
Okay. And do you know what the policy or rule is in other states regarding the public records exclusion?
Initially, the first time that I asked the question was at the Southern Area Workers' Comp Associational Convention, and the room laughed. Nobody else did it. Now, I think our research has indicated that there are a lot of states, and they do it different ways, but generally, certainly among that group, everybody else, that list is a protected list in those states. Now, when Seth comes up, you may know better than I, but I researched it pretty hard. Again, this was not something I went over there to do, not something that's on my radar screen. The opinion that I'm expressing is kind of a personal opinion, Senator. I believe that an injured worker, whether he works on a state job or a private company, he works for a private construction company and gets hurt, I would think there would be a reasonable expectation that when you filed something with the state, a state agency, that you would have reasonable expectations that would be protected. And again, even in this crowd, we're all mixed up on the way we believe this. Y'all will ultimately make that decision. But, again, the first time I heard was somebody that was shocked that they turned in a form to the state and the state mailed their name out to somebody to contact them. And that's how it got on my radar screen. It hit me odd. Others obviously have different opinions, and that's what we're going to do. We will discuss it here, and then y'all will be the ultimate deciders. Okay. There are 143 other, situations that are exempt from public records, and they're all over the board. If you read through them, I've got a list. So it's not like we're the first person, to come with this issue. But ultimately, y'all hear the debate and y'all make that decision.
So there are no restrictions, for example, HIPAA has a certain exclusions that are required by law. There are no, you don't fall under HIPAA, first of all. even
First of
though
all, we
these
don't
are-
fall under HIPAA.
These are health-related situations, am I
Yes, sir.
right?
You hit it on both angles. I had the same question. We don't fall under the HIPAA laws per se, but in addition to that, we don't provide any medical information. What we are saying is that they filed a form saying that they were injured. So we don't say they broke their leg or they fell off the scaffold or somebody dropped a hammer on them. We just, that's, what we release is just, this is an
The
injured
claim has been filed.
claim has been filed, and
by-
this is,
By individual X,
that's correct.
but nothing about the nature of their injury is included in that information.
There's nothing in there about the nature of the injury. One of the bills that was filed last year was going to require us to redact that information, and I asked the chairman, to, please do something with that, because right now, we just supply the list. If the bill passed that we had to redact information, then we'd actually have to go back to 13,000 potential forms, and we can't even do it by computer. We'd have to go back through and hand redact that information. That information is not getting out right now, only the name and address.
Thank you. All right, and you mentioned that you all have about 800 COVID-related cases that have been
It was-
filed?
I didn't check. I haven't checked since about last Thursday, but I think 778 was the number, pulling that out, but right at 800, yes, sir.
Okay, have you approved any of those claims?
No, sir. Well, where they are right now, they really, we don't have our fingerprints on them. They have been filed. So right now, the first filing will be between the employers and the employees. If the carriers decide to pay it, we don't see it. If they did not, then we'll, the process will start. And I guess the attorneys can discuss it first. Ultimately, it would come to our judges. If one of our judges ruled and one side or the other appealed, then the commission would get it, and then one side or the other would appeal, and the high court would get it. I kind of anticipate seeing that. I think I'd be surprised if I didn't see that happen.
But at this point, the commission has not approved any COVID-related claim.
But again, at this point, we have not approved or disapproved. It's not our hands. 5 of them apparently are on the docket. Apparently they've been, and I'm not familiar with individual cases. This came as a bulk number, but apparently 5 of them are on the docket to be heard, which means that they were denied by the carrier or the employer. So one of our judges will hear it, and then they will make a decision. And again, I'm pretty sure that no matter which way the ruling goes, we will ultimately get to make a decision. And then, no matter which way our decision goes, I would suspect the Supreme Court would get to hear that.
Are you aware of any other states that are getting COVID claims filed, and whether there's been any disposition on those cases?
Yes, sir. I think all 50 states have had claims filed. There are states that jumped out in front of this and passed legislation. The legislation is varied in the way that it addresses the issue. There are a number of states that basically passed laws that said that it would be presumed that you got the virus at work if you worked in, and then they define, and it's from as narrow as hospital to frontline worker. So frontline worker, that again would be up to somebody to decide. I think 17 states did something in that realm, and then the rest, you still have legislatures like yourselves who are still meeting.
And I would imagine that most of those almost 800 claims are from first responders.
I think their intent was to narrow it down to people who really would be most likely to have gotten it at work. But again, Senator, it's broad. It's first responders are named, healthcare workers are named. in some bills in some states. By the way, some of these states have passed laws. Some of these are still being debated and considered. But again, they're as narrow as medical professional and healthcare worker and first responder, and as broad as frontline worker. I saw that in one summary, and frontline worker, it doesn't define it. It just, I guess that could be the cashier at a grocery store. I mean, that pretty much puts you in public face.
Okay, and then on another subject, are there COLAs built into the payment system for the 450 weeks?
No, sir. It's statutory. Those are hard statutory limits. Said COLAs, right?
Yes.
They're hard statutory limits.
Thank you, Mr. Commissioner. Thank you, Mr. Chairman.
Thank you. In fairness,
I got through that without the cough. I asked my counsel, I said, if I say something wrong, cough a couple of times.
Thank you, Commissioner Foreman. In fairness to other speakers, we appreciate, we're going to move on, and we sure thank you for your expert knowledge. Obviously, the governor made a great appointment, and you know your subject very well. And thank you, other commissioners, for being here. Beth and Mark, thank y'all for your time. So thank you, Commissioner.
Thank you, Mr. Chairman. I thank the committee for your indulgence, and we're going to answer that one question, but if you have other questions, pick the phone up and call us. We'll answer your questions. Okay, thank you, Mr.
Thank you
Chairman.
so much. We'd now like to have Seth Thompson join us. He's a partner with Maggio Thompson LLP. Seth's an attorney, and he deals with workers' comp issues. I know your whole practice isn't workers' comp, but pretty much daily, don't you?
Pretty much daily, Mr. Chairman. Thank you for allowing me to be here. Thank you, Senate committee members. I'm a local lawyer. I'm a Jackson lawyer, but the vast majority of my practice is workers' comp, and that's been the vast majority of my practice since I've been a lawyer. And I'm here today to speak on behalf of my law firm and several other small and mid-sized law firms throughout the state who handle these workers' comp claims. Senator Horn, you had asked a question earlier. You were asking questions about benefits, and so I wanted to speak on that just briefly. Chairman Horn did a really good job of giving us a really broad overview of comp, so I'll be specific. You asked about benefits in Mississippi, how we compare. Senator, you also asked how we compare with other states. The average weekly wage in Mississippi right now is $505. That's 50th. Arkansas is 49th. They're $100 ahead of us. So our average weekly wage right now, the cap is $505. Louisiana is $705. Alabama is $920. Texas is $971, and Tennessee is $1,094. So we're behind. Our benefits are pretty low. But specifically, one of the things that I want to talk about, and Chairman Formby addressed this somewhat, is this Freedom of Information Act request. So the workers' comp legal community in Mississippi is fairly small. There aren't a lot of practitioners. And I think part of the reason for that is because workers' comp is pretty confusing. It's just a whole separate area of the law. It has a different vernacular. It's got terms that you don't necessarily hear, like indemnity and wage earning capacity and industrial loss and TTD and PPD and PTD. I mean, you have all these different terms that are confusing. And so when I started practicing workers' comp, I practiced for probably a good 6 months, exclusively workers' comp, before I felt comfortable with it. It's confusing. And I'm a lawyer. I know how to go look at statutes and read case law. And so when these individuals who are hurt at work, you know, when you get hurt at work, you're probably going to be hurt one time. You're probably going to have one workers' comp claim in your life. That's what we see. You know, you get hurt and you probably haven't had a claim before. You're probably not going to have another one. And so they're thrown into this mix and they're confused. They're hearing these terms. They've got questions about how they're going to get their medical treatment. They have questions about how they're going to be paid and how they're going to take care of their families. And the only people they're really getting information from is going to be an insurance adjuster. You know, so if you think about that for a second, that's just because of the way the system is set up, not just in Mississippi, but across the country, that insurance adjuster is going to be adverse to the claimant. That's the way it is, unfortunately. And so that's who they're going to get their information from. So a little more than 10 years ago, I believe it was, you know, maybe 15 years ago or so, Steve Funderburg's here, and he's been around and could probably provide a pretty good history of it. Attorneys started to collect information from the commission and send informational brochures to these claimants. These pre-approved by the Mississippi Bar Association. It has some general information in there and invites the claimant to call for a free consultation. And so it has to comport with the Bar Association's rules. We have to have solicitation material on there. If the claimant doesn't want it, they can throw it away. If they do want to look at it, there's some information there that will give them an idea of what they're entitled to. And it works. These people, they will get this information and they'll call and they'll have questions. Sometimes they need to hire a lawyer, sometimes they don't. But we're there to offer advice to them, to answer whatever questions they have. And some of these questions, I mean, they're incredible. You know, they ask, well, I didn't know that I could hire my own, or I could go see my own doctor. I thought I had to go to the nurse practitioner at the plant I work in. You know, or I didn't know that my overtime pay is factored into my average weekly wage. And I can promise you that, you know, not all insurance companies are terrible by any means. We have some really good ones in Mississippi. But a lot of insurance companies, you know, elsewhere that have some policies here, they don't do a really good job of taking care of these claimants. They're under no duty to tell these claimants what they're entitled to or anything like that. They're certainly under no duty to tell them what the insurance company's responsibilities are to those claimants. And so, you know, the Freedom of Information Act request, there's no HIPAA violations. To your point earlier, we don't know what type of injury they have. We don't know where they work, how long they've been working there, or anything like that. All we get is a name and their address and an alleged date of injury. We send them information. They give us a call if they have any questions, and that's pretty much it. It's just, you know, to give you an idea, though, of just how confusing workers' comp is, I handled a claim for a gentleman a while back. He was actually an attorney, and he was a member of this legislative body for a very long time, and he had a workers' comp claim. And when I handled his claim, now this was a lawyer and a legislator who had voted on workers' comp issues in the past, I had to explain to him that he didn't get pain and suffering on a workers' comp claim. And I had to explain to him that his wages were going to be capped at a pretty low cap. And so it's not just, it's confusing for everybody. It was confusing for me. It was confusing for that legislator. It's certainly going to be confusing for Mississippi's workforce. And so, you know, the system that we have in place right now, it works as far as getting information to these injured workers. But that's pretty much all of the things that I wanted to talk to you about. Like I said, Chairman Formby did a really good job with an overview, but I would invite any questions that anyone.
Thank you. Mr. Blackman?
Thank you, Mr. Chairman. Chairman Formby said that you go to the administrative judge first. Is that correct?
If you have a case,
Yes.
you do. If you have a controverted case, it goes in front of an administrative judge.
And if you're not satisfied there, then you go to the Workers' Comp Commission.
Then you appeal it to the full commission, and there are 3 commissioners. It's a kind of a strange system in that the full commission is actually the true trier of fact, and they don't necessarily hear testimony, live testimony or anything like that. The administrative judge handles that. The transcript is then provided to the full commission on appeal, and then that full commission sits as a trier of fact, just on the record.
And if you're not satisfied with the commission, it can be appealed to.
To the Court of Appeals or the Supreme Court. It can be appealed to the Supreme Court. Typically, those cases are assigned to the Court of Appeals.
Do you know how other states handle this in terms of you're going to judges first who are lawyers, and then you're going to a commission that some of which are non-lawyers?
I really don't. I'm not sure how other states have addressed that as far as procedurally. I don't know the answer to that question. I suspect it's probably pretty similar to what we've done here.
Thank you.
Willis?
Thank you, Mr. Chairman. I want to ask a follow-up question. Senator Horn raised a question and he gave an example of a 25-year-old who was injured. Under current law, 450 weeks is the max that you can receive as far as recovery. Is that correct?
That's max, Senator.
So could you talk about whether or not that changes if that 25-year-old had a permanent disability versus if that 25-year-old actually died what effect, if any, would that have on the recovery?
It would, well, it's a 25-year-old, so if he has a permanent disability, if he's a quadriplegic, he's going to be capped at 450 weeks as far as his indemnity benefits are concerned. Indemnity, that's your wages, right? Now, he may have medical benefits that will carry on throughout his lifetime, but his indemnity benefits are going to be 450 weeks. That's roughly 9 years. After that, figure it out, or we will take care of it as taxpayers. But that's the system that's in place now. If he were to die, if he were unmarried, there's no benefit other than like a funeral benefit.
And if that 25-year-old actually died on the job and had children, what effect would it have on
If
his
he
children?
died on the job without children,
With children.
with children, then his children will be entitled to a small percentage of the 450 weeks. So they're not entitled to the full benefit that he would get. They're entitled to a percentage. I'm not sure of the exact percentage. Megan may know it. I think the spouse's percentage is like 35% of 450 weeks, and then there's a graduated scale for each individual child dependent.
And after 450 weeks, that's it.
That's it.
Whereas that, if he would have actually lived, he could have worked for 20 years or 30 years on the job, but as a result of his death, his family still will be kept under the current law.
Right. There's not a lot of money there to be given to the survivors of a worker who's passed away.
Thank you.
Warren, for a question or two at the most, maybe?
Question or two at the most, Mr. Chairman. So the expectation of any support from the state beyond that 9 years or 450 weeks for a kid who has a permanent disability, the expectation is that, okay, kid, you're on your own after the 450 weeks, even though you have a permanent disability that was caused on the job.
Right.
And so Division of Medicaid or Department of Human Services might have to pick up the slack as far as that person, if his earning potential has been greatly diminished and he needs help with doctor bills, with putting food on the table and so forth, those other agencies would be expected to pick up the slack.
That's typically what we see. We typically see people who try and get on Social Security disability if they've had a really debilitating injury and can't return to the labor force.
Yeah, okay, and back to the question on this exclusion of public records. I think the commissioner mentioned that there were about 12 law firms that dabble in workers' comp, and maybe 4 are really heavily involved. Is that accurate?
Probably get the list.
Okay, and so out of thousands of law firms, only about 12 are in this sphere.
We don't have thousands of law firms who practice.
How many law
workers'
firms
compensation.
would you estimate are in Mississippi?
I really don't know. I can get you that information. I don't know how many practitioners we have. You're going to have a few lawyers who will handle a workers' comp claim here and there every once in a while. It's not really part of their practice, but as far as attorneys who do that, and even defense firms who primarily practice workers' compensation defensive claims, there just aren't very many. I'm not sure of the exact number, but there aren't. That's why, I mentioned it earlier. It's a really small legal community. We all know each other.
So would you say that this is a widespread issue or pretty narrow?
As far as claim attorneys are concerned, pretty good many claim attorneys send that mailer and have for a long time. So, I'm not sure whether I'd categorize it as widespread or what, but there are a good many law firms who I know that send that brochure.
So would you say that the average worker is astute enough to know that if they have a situation with the claim, be astute enough to know, well, as it relates to this, I'm in over my head, I need a lawyer. Would the average person be astute enough to make that determination?
No, absolutely not. I mean, and it's unfortunate that they can't, but they're not. The average lawyer isn't astute enough to know how to handle a workers' comp claim if they were injured themselves, because they don't know what a loss of industrial use is. They don't know how an impairment rating or permanent restrictions will impact the amount of money their claim is worth. And there are a lot of factors that go into that: their educational background, their work history, what kind of injury they have. There are a ton of factors that go into that. There are experts that have to be hired, vocational rehabilitation experts. We have to go talk to their doctors. We have to figure out how this injury is going to impact their ability to earn a living, not just now, but 10 years from now. The average person, no, they can't do that.
Thank you, Mr. Thompson. Thank you, Mr. Chairman.
Thanks, Senator.
Yes, we sure appreciate you
Hey,
being
I
with us.
appreciate
Thank you so
your
much.
invitation, Senator.
Thank you for your time and your obvious knowledge. Okay, we're now going to hear from Chris Patrick, Executive Vice President, Chief Operating Officer of Ergon, and also is Houston Ezel is with you. Is Houston going to join you at the podium? Houston is the President of Risk Management, also for Ergon. And of course, Ergon is a very large employer here in the Metro Jackson area, based out in Flowood, I believe.
That's right. Thank you to all you committee members. Thank you, Chairman Michelle. We're excited to be here. We're grateful to you and your staffs for giving us a few minutes to talk to you. My name is Chris Patrick, as has been stated, Chief Operating Officer for Ergon. I've been with the company 20 years. I'm proud to say I think we work for a good family. We're a company who genuinely wants to do the right thing. I've got with me Houston Ezel. He is our Vice President of Risk Management. And to sort of put you at ease, I mean, you clearly deal with some very complex issues. And to sort of put you at ease, we have no specific ask. We're just here to tell you what we're doing that we think impacts the lives of our workforce to the better and ultimately to our communities. And hopefully those shared learnings can benefit us all. What's been passed around is kind of an overview of Ergon. For some of you who don't know, I'm not going to hit that because frankly I don't have time and neither do you, and I want to make good use of it. But at a high level, we are a Mississippi born company by Mr. Lampton, Leslie Lampton Sr. back in 1954. We started as an energy services company right here in Jackson. Today, we have grown into a company. We employ 3,200 employees all across the globe. A lot of our products are transported all over the globe. I'm also proud to tell you we have of that 3,200 employees, about 1,100 of them are Mississippians. So we have some significant facilities here, Vicksburg, Jackson area, as well as Hattiesburg and all around the state. Business segments broadly, won't go into details: refining and marketing, asphalt and emulsions, midstream and logistics, specialty chemicals, oil and gas, construction and real estate. So I think you get the picture. We pretty diverse background, about 70 subsidiaries across those 6 business segments. So our mission has always been and will continue to be, this is the way Mr. Lampton always said it: meet needs, support families, serve customers. It's that simple. That's what we do. So we were asked to come talk to all of you about, sort of a feel-good success story about what we're doing from a safety to promote the health and welfare of our workers. I got to deviate just a little bit from that topic because success story indicates that you have arrived and we have not. For us, it's a journey. We're better than we were, but we recognize we've got progress in front of us. And I think talking about that progress that we need to make is probably important and relevant to the topics that you deal with. So give you a little bit more background. By any metric you look at, Ergon's been a really successful company. But I will be honest with you, back in 2017, our board of directors challenged us because they said, hey, we're profitable, we're providing returns, we're employing a lot of people. But candidly, our safety record was not where it needed to be. For a company our size, we had far too many injuries. You know as well as I do, ultimately that results in the kind of complex issues that you all deal with. So the challenge for our board was, how do you deal with that? So we really had to look ourselves in the mirror and think about that. And the first thing that we realized in 2018, we started basically an employee engagement campaign. We called it Target Zero. And we spent, probably a little over $1 million on simply explaining to our workforce how important it was to us that they go home safe every single day, that we prioritize that over profit. Because what we recognized is the first battle wasn't policies or procedures. It was actually a psychological thing. They needed to hear us say that it was more important than profit, and they needed to visibly see signs of that. They needed to see us living that out consistently every single day, every decision that we make. So again, we haven't arrived, but I feel good about the progress that we've made. And that success doesn't go to me or Houston or any of us that work over here on Lakeland Drive. It's those 1,100 folks in Mississippi that ultimately make that difference, because simply by talking about the importance and demonstrating that it was important to us, we cut our recordable rates in half, just, basically over the course of the year. And so we're really proud of that. We're really proud of our workforce. We passed out a couple of documents. One is that brochure, one is a chart. And in that chart, you can see some of the standard OSHA metrics that we look at, that we have to report on. And you'll notice the significant step change that occurred over the last 2 years. Again, we're really proud of that. That's not really the story that we want to tell you today, because I have a different reason, quite honestly, for showing you that chart, and it is that although we have made significant improvement, my guess would be it would probably greatly impact your perspective and your interpretation on that chart if I told you cutting that injury rate from basically 2 something to 1 something, if one of those was your son or daughter or sister or brother and so on. I mean, once you put a face with it and it's not a statistic, it means something different to you. And it would certainly change your perspective if I told you that injury that's reported on that chart was a catastrophic injury, a burn or an amputation or something like that impacted somebody's life. You would say, well, that one is not acceptable, and you would absolutely be right. We wholeheartedly agree. So, what I'm telling you now is we're on this journey. And so what we see as the next phase is, in order to really impact safety culture in our company, my point in telling you all that background about how you interpret that chart is that we recognize that we had to make it personal to our employees. Personal in terms of their family, their coworkers. We talk about our company as not just family owned, but a business family. And so we're in that process. That's kind of where we are in that journey. And I think one of the points I would make, again, is that as business leaders, you as committee members, we look at statistics a lot of times and we have to make judgments off of that. But sometimes the statistics lie to you and they don't tell you what you need to be working on. And so as a company, even though we're mandated to report on these things by OSHA and other regulatory agencies, what we're really doing is moving more towards what we consider leading indicators. Those would be things like leadership engagement. So, when you look at safety behavioral science, you'll see that the more leaders ask the employees, the people who actually know how to impact this better, the more we engage them and ask them questions about how to improve things, the better they'll respond, the better you will improve. Energy-based hazard recognition, that's basically educating our workforce on how to recognize the hazards. Audits where we observe high energy, interactions that our employees have and learn from them. And then finally, just learning teams. I think you would be interested to know, again, just going off that chart, is that, give you 2 quick examples, a wasp sting versus, let's say, a high energy power line strike. One of those is an OSHA recordable. The wasp sting can be an OSHA reportable. If nobody gets hurt on that high energy power line strike, we just get lucky, let's say, guess what? That doesn't show up on any statistic, but which one is the more important thing that we should be focusing on as a company? And so that's my main point. Again, we're on a journey. You all deal with complex issues. We deal with complex issues. I'm really happy to tell you that, and I'm going to turn the floor over to Houston. I'm really happy to tell you that our Vice President of Risk Management, he's spending more time today talking about how we prevent injuries from happening in the first place, rather than the complexity of how we're trying to manage them on the back end. He'll talk about it. What we have seen as a result of this focus and this journey that we're on over the last 2 years is actually our claims have dropped significantly as a result of that. People a lot of times, and companies are notoriously guilty of this, is we think that there's a trade-off between investing in safety of the workforce and profits, and that's just not true. You can look at it, oftentimes the companies that behave with a high safety record tend to be the most profitable. So May not be the exact charter of this committee, but, you know, we're a Mississippi company and we're really proud to be a Mississippi company. We're proud to pay, you know, high wages to a lot of Mississippi workers. We think that certainly our energy is better spent on the front end of dealing with these things and preventing them from ever happening in the first place. And that may be a good place for, may not be the exact charter of this committee, but we're just here to offer our service as a Mississippi company. We're already working with the MEC and MMA on, you know, kind of joint partnerships, and any ideas that any of you have, how we can better contribute to the community. You know, we're all ears. We're here to serve. We're proud to be part of this great community. I'll turn it over to Houston for a few words and then any questions.
Sure, thanks, Chris. Thanks, members of the committee. Seth's not wrong. Workers' comp is confusing. As some of you know, sometimes the employer risk management and employee relationship as it comes to work comp aren't necessarily synonymous with taking care of employees. Oftentimes that can be an adversarial role that we see. When an employee gets injured, they're lost. They don't know what to do. They're worried about their family. They're worried about providing for their family. They're worried about their health. I'm fortunate to work at a company that sees value in our role in risk management is to communicate with those employees, to educate them, to help them through that. We've got adjusters that we work with and they do a great job, but that's not their role. These are our coworkers. These are people that we work with day in, day out, and we want to be that resource for them. I'm also fortunate, as Chris mentioned, to spend much of my time working really on how we prevent injuries and what do we do to empower our employees to take ownership of their safety and those around them. But for employees to feel that empowerment, they have to know that management listens, management cares, and management's going to provide the right resources to address their concerns. At Ergon, it's three simple things. It's what are you doing, how are you doing it, and do you need anything to do your job safer? We strive for target zero, but we're not perfect, and there's room for improvement. One example of this in Ergon is an incident where we had a significant injury with one of our employees a couple years ago. This employee required multiple surgeries, was out of work for well over a year, and to this day suffers the impact of his injuries. When it came time for that employee to be released and potentially come back for work, none of us expected that this employee would come back due to the settlement that he had received directly from us. It was a great news for us when that employee shared the desire to come back to Ergon. He wanted to change positions and he wanted to move into a role that could educate others on the importance of safe work practices and incorporating safety in every task that you do. I'm proud to say he's working today to accomplish that mission, and we're better company for his leadership. Another example of the culture of Ergon is how we've weathered the current COVID-19 pandemic. Early in the pandemic, Chris assembled a group of leaders to help guide the company through the crisis. While remaining operational was a goal, employee safety was first. An example of this was our recent turnaround in Ergon Refining in Vicksburg. If you don't know what a turnaround is, I'll explain it this way. It's where you shut down operations for a period of time to perform maintenance and projects that you can't do while the facility's operating. It's a chaotic time. These turnarounds happen about every 4 years or so. They usually last about 4 weeks, and they're day and night operations. And they're critical to our ability to maintain our assets and protect employees from catastrophic losses. They're planned well in advance and years ahead. In a typical day inside our refinery, we have 150 people, employees and contractors that are working. In turnaround, that number jumps to 700 people per day. So a significant number of people. When the COVID numbers started to rise significantly in March, we were already in the middle of our turnaround project. We had the refinery shut down and we faced a significant challenge. One day we had a contractor come down with COVID-19 symptoms, and there was an immediate concern about how this could impact the other employees and contractors. Jeremy Kaiser, our refinery manager, made the immediate decision to shut down operations for a period of time. The next 3 days were spent planning on what protocols needed to be in place, what decisions did we need to make as a company to better protect employees. Fortunately, that contractor tested negative. However, we increased our efforts to recommend to employees the benefits of socially distancing, hand sanitizer, face shields. We engaged our EHS team to act as hygiene monitors. We cleaned hands, we cleaned toilets, we cleaned everything. And most importantly, we asked employees how they were doing. But perhaps the biggest decision was to drastically reduce the headcount inside the refinery. We extended our refinery turnaround from 4 weeks to 8 weeks. That decision cost millions and millions of dollars to Ergon, but it was the right decision. Not one leader in Ergon, not one owner of Ergon ever questioned that decision. It was always about what's the right thing to do for the employees. I'm proud to say that we made it through that turnaround with 0 injuries and zero COVID-19 cases. This is a testament not to the leadership, but to the employees that took ownership of their safety, and to Jeremy and his team for giving them the resources to do so. Early on in the pandemic, Chris made a commitment to our employees. The commitment was that the company would be completely transparent about the issues and challenges we were facing as a company and the steps that we were going to go through to protect employees. That transparency took many different forms. Chris and other leaders recorded sometimes daily videos for employees to educate them on changes in CDC guidelines or critical infrastructure guidelines so that they knew we as a company were on top of it and were looking out for them. These video messages were simple: encourage employees, show them that we care, and open a dialogue with them about their concerns. Chris ended every message giving his contact information. And those employees would contact Chris, and then our COVID-19 committee would take those and address the concerns and adjust our strategy. Due to Ergon's size, we were not eligible for any of the PPP loans. However, that did not impact any decisions that we made in relation to our employees. We went above and beyond. When employees got sick, they still got paid. Employees were home taking care of loved ones or in isolation, they still got paid. To this day, Ergon continues to go above and beyond to take care of its employees during these challenging times. We're not perfect. As Chris said, it's a continuous journey. It's not a campaign or a project that will end at some time. Instead, it's a continuous cycle of improvement. We make mistakes, we learn, we educate, and we empower our employees to take action. Committee members, Chairman, I want to thank you for your time today of sharing the Ergon success story.
Questions from the committee? I'd like to ask a question. As large a company as you are, obviously you deal with many vendors. Is it a company policy that you would require all your vendors to carry workers' comp, even for a small item? Let's just say something like if you had to have a tree removed on your office complex. I'm in commercial real estate business, and we run into that all the time. There's a lot of people who are 5 or less, and they don't carry workers' comp, and it falls on them, your company to cover them.
Yeah, it's a good question. We do have a very robust contracts management department that really looks at what's the work being performed. Our standard agreements are absolutely require workers' compensation as well as the other liability coverages. We do run into the situations you're talking about where you have a sole proprietor that maybe we will grant a waiver for. But we've also had situations that based on the risk, even if it is a sole proprietor, we may ask that contractor to get workers' compensation insurance. So it's a case-by-case situation, but the vast majority of all of our contractors are absolutely required to have workers' compensation.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Zell, is there any one thing that you can point to that you attribute your success in getting your safety numbers to the point where they are today?
Yeah, you know, I tell you, we really, I hope you feel the sincerity, because we really do care about the employees. That's one of the things our people tell us. That's one of the reasons I work for the company, quite frankly. I've been here more than 20 years, and I felt like even the ownership cared for me. I think the issue was we weren't asking our employees to take additional risks. We never said, hey, we want you to do this hazardous thing over here that may cause you to get hurt. And so it really kind of puzzled us as to why that's happening. I mean, we genuinely care about them, and I think honestly it's just their zeal. We have we measure employee engagement like a lot of companies our size do. We have really good engagement scores, which tells you, they generally like working for us. And I think sometimes that can play against you, and so I think it was just us slowing down, telling them that, look, we appreciate that you want to take care of our customers. We appreciate that you want to improve our efficiency and profitability and all those things. But the most important thing is you going home safe every day. And I think it was just slowing down to make sure that and things like, because those employees, they know when we shut that refinery down, it's, you all probably don't appreciate it, but they gasp. How could we do that? That is, as Houston said, millions and millions of dollars. But, there was an old saying from, preachers say, show me your pocketbook and I'll show you where your priorities are. And that's what I would attribute it to, is just consistently demonstrating that, no, we really do. It's not a slogan. We got banners and paraphernalia all over the place, but this is not a slogan. If you feel unsafe, we want you to you have authority to shut that job down until you feel like you're in a safe. And, the real test for that is the first time one of them does it, how you respond, whether you respond in a threatening way or whether you respond in a, hey, you're right, we ought to take a second look at this. And you do that just a few times, and suddenly their whole mentality to it starts to change. It's a long-winded answer, but I hope
Yeah, thank you. Mr. Patrick, I don't know I think it might have been Mr. Zell who mentioned you all have a benefits package that provides support to your employees who might be injured on top of whatever workers' comp provides.
Yeah, so I think maybe to clarify what I was regarding, we as employees in risk management, Lori Graham is our director of claims and does a great job of, hopefully we view ourselves or employees view us as a benefit to them when they have that workers' compensation claim. But yes, to answer your question, we have gone above and beyond what the requirement is. I'm not going to stand before you and say it's every situation, but we do look at it and say, what are the needs? What are the issues here? Again, I came from a public company, large public company, and going to a large private company with owners that are very engaged. I give our ownership a lot of credit that their focus is on the employees and what do we need to do for them. And I've yet to see anything that we've suggested that our gun management would say no to when it comes to taking care of it. So we do really look at each and every situation to say what are the needs here and what can we do to help this employee.
Thank you, Mr. Chairman.
Anybody else? Thank y'all so much. My father was a contemporary of Mr. Lampton's and was in the same office building in 1954, and Mr. Lampton and Kathy Stone started Ergon. And she's still with you, isn't she?
She still was.
Kathy Stone.
It's,
Congratulations on such a wonderful homegrown success story.
Thank y'all for your time. Appreciate it.
I want to thank the members of the committee so much. Yesterday, we had all 13 members of the committee. We had one who had a previous conflict today and couldn't be with us today, but that is tremendous. I don't think we draw that many when we're in session, having 13 committee members attend the meeting. Thank y'all for your diligence and for your good questions on the different subjects we had, and I'm sure we'll be having some legislation that'll address some of these issues to come up in just a few months, actually. and the knowledge you gained today will be helpful. Meeting's adjourned. Thank you. We'll be here next week on alcohol.